I am in a difficult position. I spent the last few days preparing for tonight's event. And all my thoughts have been taken by my learned friend, Thomas.
But not the anecdotes, no? But not the anecdotes.
All right, okay. Thank you, Moderator Yang Berhormat Cik Rizwan. Yeah. Mrs. Gurmit Kaur and family members of the late Mr. Karpal Singh, Yang Berhormat Anthony Loke, Mr. Lim Kit Siang, honorable ministers, distinguished audience, ladies and gentlemen, salam sejahtera, and a very good evening. I would like to thank the DAP and in particular Deputy Minister Yang Berhormat Puan Teo Ni Ching, I believe she's in China tonight, right? For inviting me to this event 10 years on, honoring Karpal Singh as a panel speaker. I find it indeed an honor and a privilege to be so invited, for the late Mr. Karpal Singh was a personality, was a person whom I have high admiration. He is a fierce defender of the Constitution. That being the case, let me say a few words about the Constitution and the need for it to be defended before I go directly of my interaction with the late Mr. Karpal Singh. So a few words, if you can bear with me, on the importance of defending the Constitution. The Constitution is the life of the nation. Without the Constitution or without an effective Constitution, our nation is doomed to be a failed state. The Constitution is the guiding light without which there will be social disorder and even anarchy. Without a Constitution or an effective Constitution, and as always happened, the powerful will oppress the weak. The rich will oppress the poor. And the majority, there'll be a tyranny of the majority over the minority. Hence, the nation needs a constitution, and the supremacy of the constitution must be defended at all costs. We have the judiciary to interpret the Constitution. We have the judiciary to protect and to enforce the Constitution. For the judiciary to defend the Constitution, there have to be courageous judges who are learned on the Constitution and judges of high integrity. The current judiciary, under the leadership of the current Chief Justice, has done an excellent job defending the Constitution, particularly in initiating the doctrine of the basic structure. By this doctrine, Parliament can never ever amend the Constitution in a drastic manner so as to change the basic structure of the Constitution. Such basic structure includes fundamental liberties, power of judicial review of the judiciary, and the doctrine of separation of powers. The basic doctrine structure has been emphasized time and again in cases like Sivarasa Rasaya, Semuanya Jaya, Indira Gandhi, Alma Nudo, and Dinesh. But we cannot expect to depend on the judiciary alone to defend and protect the Constitution. There must be a will on all organs of government, the executive, the legislature, and the judiciary to observe, to respect, and to defend the Constitution. The temptation of the executive arm of the government to violate the Constitution for the sake of political expediency must be resisted. Ladies and gentlemen, now allow me to take the liberty to say this. Had there been respect for the sanctity of the Federal Constitution, the infamous Operasi Lalang of 1987 would not have taken place. Under this Operasi Lalang, in one swoop, over 100 innocent citizens were arrested and detained without trial. I feel emotional, I feel this. The late Mr. Karpal Singh was among the victims of Operasi Lalang. I think, I propose that the present government, although has got nothing to do with Operasi Lalang, should offer an apology, a public apology, to the victims of Operasi Lalang. Again, had there been respect for the sanctity of the Constitution, there would not have been a dark spot in the history of our judiciary in 1988. Our respected and esteemed judges, like the Honorable Tun Sali Abbas, Tan Sri Wan Sulaiman, and Dato Josia, would not have been tribunalized and dismissed. Likewise, Tan Sri Kamaruddin, Azmi Kamaruddin, Tan Sri Yusofi Abdul Qadir, and Tan Sri Wan Hamzah would not have been tribunalized and suspended. The above two disgraceful episodes must never ever be forgotten because they are lessons to be learned. We as a nation must never allow another Operasi Lalang to ever happen again. We as a nation must ensure that there shall never ever be a disgraceful assault on our judiciary. Having said that, as my preamble, I shall now go something that's more direct. My personal experiences with the late Mr. Karpal Singh, whether inside or outside court. The late Mr. Karpal Singh and I go a long way to the early 70s when I was a fresh magistrate in Alostar, and he was also a young lawyer in Alostar, also in Alostar. I cannot recall of any significant or incident then to relate here, but in court, Mr. Karpal Singh was ever so courteous. One thing that I can remember was that even in those early days, Mr. Karpal Singh was a busy and popular lawyer. He was hardworking. Many in town wanted to engage Mr. Karpal Singh as his or her lawyer, especially in criminal law matters. Hence, even as early as those years, Mr. Karpal Singh as a lawyer was already famous. Then, in the early 80s, I was a senior assistant registrar senior assistant parliamentary draftsman in the Attorney General's chambers. And Mr. Karpal Singh was a member of parliament. As a parliamentary draftsman, I had to be on parliament duty from time to advise ministers, particularly when a bill I drafted was to be debated. It is here in the corridor and lobby of Parliament that Mr. Karpal and I would bump into each other from time to time. This time, not in a formal setting as a magistrate and a lawyer, but as friends. We would be exchanging warm smiles, greetings, and pleasantries. In Parliament, Mr. Karpal, as my friend Tan Sri Tom has said, Tommy Tom has said, Mr. Karpal was a fearless MP and who stood his ground if he believed he was right in principle. There was an incident that I would like to share here. One day I was on duty in Parliament and I was sitting on the government officer's side, but quite near to Mr. Karpal Singh. He was having a serious altercation with a backbencher who was rude and behaving in an unparliamentary manner. Which party that backbencher belonged, I won't mention tonight, but I'll leave it to your imagination. I cannot recall in detail what the argument was about. However, as a result of this altercation, Mr. Karpal Singh sadly was ordered out of the day one by the speaker. I was stunned and appalled by the speaker's ruling. It was so unfair to Mr. Karpal Singh. For having observed the conduct of the backbencher MP compared to the dignified conduct of Mr. Karpal Singh throughout the altercation that afternoon. If at all one was to be ejected from the August House, it should have been the backbencher MP who had misbehaved, and certainly not Mr. Karpal Singh. In court as a lawyer, Mr. Karpal Singh frequently appeared before me as a magistrate, as a high court judge, and as a court of appeal. I must say that he was a true gentleman, very professional. He observed court ethics. He was always brief and always to the point. In cross-examination or in submissions, he did not raise many issues. He just raised the pertinent points. Trials conducted by Mr. Karpal Singh as counsel were always cordial, pleasant, and never got protracted. There was this incident when I was a fresh judicial commissioner and was trying to find my feet, very inexperienced. A young man was tried before me for drug trafficking, an offense that carried the mandatory death penalty then. I was newly appointed as a judicial commissioner, and so in the course of the trial, I made a ruling to which Mr. Karpal Singh, who was defending the accused, stood up and politely told me that I was wrong on the law. I immediately realized my mistake and apologized. I withdrew my ruling. Mr. Karpal Singh, being a gentleman, accepted my apology and did not capitalize on the mistake that I made, for instance, asking me to recuse myself from the trial. We just moved along on the trial. I was indeed touched. Mr. Karpal Singh was a lawyer who was fearless in court and persevered when he felt he had to. There was this incident at the federal court. I was at the federal court that morning as a state legal advisor of Selangor and was waiting for my case to be called. Mr. Karpal Singh sat in the front row and his case was called up first. In the course of the submission, he wanted to raise a point to which the bench was not keen to hear. The bench asked Mr. Karpal Singh not to labor on that point, but to sit down, as the federal court had already made a ruling in the past on that point. They would not want to hear of it anymore. However, Mr. Karpal Singh was adamant and refused to sit down. I recall at least twice or 3 times he was asked to sit down. Any ordinary lawyer, including myself, would have given up, but not Mr. Karpal Singh. He insisted that he be given the right to be heard. In the end, the federal court bench relented and permitted Mr. Karpal Singh to submit on that point. So, ladies and gentlemen, these are my personal experience with the late Mr. Karpal Singh that I would love to share with you all tonight. I will now move on. Mr. Moderator, allow me to move on a few more minutes. Yeah. To the legacy of Mr. Karpal Singh's defense of the federal constitution, both in court and outside the court. The legacy of Mr. Karpal Singh's defense of the federal constitution in court. For that legacy, I have prepared here the landmark case of Te Cheng Po. But as my learned brother, Francis Thomas, have touched on that case, Privy Council case, important case on emergency, I will not touch on that case, but just to say that the case is of great importance from the standpoint of constitutional law as it defines the limits on the power of the Agong in making emergency regulations during a period of emergency. I'll just touch on another case. This next case is the case of Chief Inspector Ong Chuan Hock. This case may not be the best candidate for me to choose, but I chose this case because Mr. Karpal Singh himself and Ms. Sangeet Kaur argued the case before me at the Court of Appeal. I hope you remember. Ong Chuan Hock was a chief inspector in the police force. Disciplinary proceedings were taken against him by the disciplinary committee of the police department under the police disciplinary regulations. In his defense, Chief Inspector Ong Chuan Hock called a witness. However, something peculiar happened during the disciplinary proceeding. Chief Inspector Ong Chuan Hock was told to leave the hearing room when his witness was testifying. No reason was given for asking him to leave the room. Thus, by being asked to leave the room, the chief inspector was prevented from knowing what his witness is going to testify in evidence, how his witness will be cross-examined, and he also will be deprived of the opportunity to re-examine his witness. In spite of these abnormalities, The disciplinary authority, after considering the report of the disciplinary authority, found the chief inspector guilty and had him dismissed from the police force. The chief inspector, represented by the late Mr. Karpal Singh, filed for judicial review before the High Court. But in spite of the prerogative facts of the case, the application was dismissed by the High Court judge. The chief inspector appealed to the Court of Appeal. At the Court of Appeal, the matter came before my panel. After hearing submissions, we ruled that the procedure as adopted by the disciplinary committee, depriving the chief inspector from being present before the disciplinary committee while his witness was testifying, had deprived the chief inspector of his right to natural justice. We accordingly allowed the appeal. This case has a bearing on the federal constitution because it is provided for by Article 135 of the federal constitution that a public officer cannot be dismissed or reduced in rank without being given the opportunity of being heard. In the case of Chief Inspector Ng Chuan Hock, his right to be heard had been impaired when he was prevented from being present while his witness was testifying. I now touch on the legacy of Mr. Karpal Singh in defense of the federal constitution outside the court. What springs to mind is a para-constitutional crisis. In the 2008 general election, the Pakatan Rakyat Coalition won the general election. Yang Berhormat Nizar Jamuddin became the Menteri Besar of Perak. However, after 3 state assembly persons defected, the whole of the government of the Pakatan Harapan government, Pakatan Rakyat government in Perak became uncertain. But his request for a dissolution of the State Legislative Assembly was rejected by the Sultan of Perak, and not only that, he was dismissed by the Sultan. The late Mr. Karpal Singh made a statement that what the Sultan did was unconstitutional. Now, Mr. Karpal Singh was merely giving his legal opinion. There was clearly nothing wrong with that. It is an innocent statement. One can agree or one can disagree with his view, but rather perplexing. He was charged for the crime of sedition. The High Court judge who tried him very rightly acquitted Mr. Karpal Singh at the close of the case for the prosecution on the grounds that there was no prima facie case. The prosecution appealed to the Court of Appeal, who reversed the decision of the High Court and sent the case back to the High Court for the defense to be called. The same High Court judge, as directed, called for the defense at the conclusion of the case. And at the conclusion of the case, one would have expected that he would again acquit Mr. Karpal Singh. No, not this time. Instead, he now fined Mr. Karpal Singh guilty of sedition, and Mr. Karpal Singh was fined 4,000 ringgit. Mr. Karpal Singh died 2 months later. His family, however, pursued the appeal to the Court of Appeal. His appeal to the Court of Appeal was unfortunately dismissed by a majority of 2-1, meaning that there was one dissenting judgment. But his fine was reduced to 1,008. Mr. Karpal Singh's family appealed further to the federal court. Ultimately, the federal court this time and rightly allowed the appeal. The federal court set aside the conviction and sentence. Ladies and gentlemen, in conclusion, the late Mr. Karpal Singh was a sincere, tireless, and a fearless defender of the federal constitution. But he had to pay a high price for his noble deeds. The nation owes immensely to Mr. Karpal Singh for all that he did in defending the federal constitution. With that, I end my piece. Thank you for listening.
Thank you. Thank you, Dato Sri, for that insightful sharing session. Dato Sri has touched on one case. I can give you a citation, 2013.